Testing, testing. You can hear it in there? Testing, testing.
All rise and be silent. The Honorable Judges, Intermediate Court of Appeals, Chief Judge Daniel Greer presiding. Oh yay, oh yay, oh yay. Silence is now commanded under penalty of fine or imprisonment while the Honorable Judges, the Intermediate Court of Appeals are now sitting. Let all persons having motions to make and appeals to prosecute come forward and you shall be heard. God save the state of West Virginia and this honorable court. Please be seated.
Morning, everybody. Will the clerk call the first case?
First up on the Rule 20 argument, Harvey Bellomy and Nancy Bellomy versus Falcon Ridge Unit Owners Association, case number 25 ICA 279, an appeal from the Circuit Court of Mercer County.
Okay, this is set for Rule 20 argument. Mr. Sad, do you wish to reserve any time for rebuttal?
Yes, Your Honor, up to the residue of time, 5 minutes.
Okay. I'll let you know when you've hit 15. Thank you. You may begin.
May it please the court, this morning, I'm Mark Sad. I represent petitioners Lee and Nancy Bellomy, who are in the room with me this morning. This appeal arises from summary judgments entered in the Mercer County Circuit Court for the Respondent Association, and then expanded on a Rule 59E order that into improper injunctive relief that was never pled nor requested by the HOA. Petitioners asked this court to do basically 4 things: to vacate the final order and the Rule 59E order for failure to provide findings for meaningful appellate review; 2, to reverse the legal conclusions that petitioners' lots are bound by the Falcon Ridge Declaration; 3, vacate the rulings that purported to divest petitioners' title to part of Lot 94 and their access easement by virtue of a statute cited in the very end of this case, West Virginia Code 36-3-11, and finally to dissolve the court's sua sponte injunction enforcing use restrictions against my clients. There are 11 assignments of error divided into 4 categories. The first one is simply our assertion that as this court reviews this case de novo, our law also requires that summary judgment orders set out findings of fact sufficient to permit meaningful appellate review, including the undisputed facts that are required for adjudication. The remedy for an order that does not set out findings of fact sufficient to permit meaningful review is to vacate them and to remand, or in this instance, we believe this court can enter judgment for petitioners. We think that that the orders are conclusory in this case. They admit findings of fact and applicable legal authorities to support the final determinations and for relief in favor of respondents. As I said, the remaining assignments can be divided into now 3 parts. Assignments 2, 3, 4, 5, and 6 all relate to this next part of this argument, which relates to whether my client's property acquired by deeds are actually in fact subject to the declaration that created Falcon Ridge. In this case, the lower court, despite several entreaties of the petitioners, failed to apply the principal applicable statute, which is the Uniform Common Interest Ownership Act, or otherwise known as UKIWA. Despite acknowledging in a stray reference in one of its orders that this Falcon Ridge is subject to UKIWA and to all of its 80 provisions, had the lower court, in fact, applied UKIWA and associated other principles of law, the lower court would have entered judgment for the petitioners in this case. I'm often asked, what is the most important provision in UKIWA? I think it's Section 1-1037, which is the definition of common interest community. In the statute, it defines a common interest community as real estate with respect to which a person, by virtue of his ownership of a unit, is obligated to pay for real estate taxes, insurance premiums, maintenance, or improvement of other real estate described in that declaration. In this case, we're going to concentrate on the obligation itself and the real estate described in the declaration.
Counsel,
yes.
in the proceeding below, was that what was that? Was that a bench trial?
There was no trial, Your Honor. It was just summary judgment based on dispositive motions filed by the
In
parties.
the order, it said in lieu of a trial, the court will decide. That sounds like a bench trial to me. Why is it not?
It was not a bench trial, Your Honor. It was just simply submitted dispositive motions.
Well, why was the transcript not attached so that we could determine?
We didn't think it was important to attach the hearing transcripts in this instance because it's a documents case based on evidence submitted by the parties through their dispositive motions.
The court explicitly says in its order on the deck action that the court held a hearing regarding the matter on November 7, 2024. At this time, both sides presented their case and the judge took the matter under advisement. Did you preserve an objection to the court that the bench trial hadn't occurred?
Your Honor, I don't recall, I don't believe so, but all the motions were submitted on dispositive motions. There was no reference to a bench trial. Only dispositive motions were noticed at that time, and only dispositive motions were argued during that hearing.
And you obviously understand the reason for our question. We would defer. There are several statements in the final order under review that certainly indicate that the court made findings of fact, and he certainly cited law that supported his conclusion. The law didn't necessarily rely on the Uniform Act, but relied on equitable, primarily the Jubb case and its progeny. So I'm curious as to how we can ascertain whether you preserved objections that from a 9-page order having 11 assignments of error. That's a hefty amount of stuff you would have needed to preserve, and we don't have a record before us indicating whether those issues were properly brought before the court. And in fact, the respondent in several areas said that they weren't raised.
Well, there was a Rule 59 motion filed to set aside that order based on the dispositive motions, and then the appendix submitted based on the record below on those motions. We feel that there was no other issue outstanding other than the dispositive motions pending before the court. Going further, Falcon Ridge admitted in its own documents that it is a planned community subject to Ukiah. Therefore, the court simply proceeded without applying the applicable law under Ukiah. Ukiah itself says that the parties may not contract around Ukiah and may not waive rights conferred by the act. In this instance, the court not only didn't apply Ukiah principles to the proceedings, but failed to even cite a single reference to Ukiah in its orders. In the motions presented before the court, we made it very clear that the declaration itself was deficient and could not be presumed to apply to my client's property, because it was missing and omitted the essential information that Ukiah itself requires, which is a sufficient description of the real estate, a non-waivable obligation, but it also stated the maximum number of lots that the declarant reserves the right to create. In this instance, it was 49 stated in the declaration. Yes?
Does Section 36B2 at SEC specifically state that a court should declare a declaration invalid if it doesn't have a description?
It would, based on the non-waivable obligation that is a mandatory component of a declaration.
But
So
does the actual statute say that a court
it does
should
not
do
say that specifically.
Okay.
But again, we look to other cases such as in Colorado, which is a Ukiah jurisdiction.
Is the Colorado statute exactly the same as our statute?
It's substantially similar to this point, where
Nothing extra in that?
it has additional provisions, but the
Okay.
courts said there that if a declaration is omitting key information, and in this instance, we're only discussing the actual description of the property itself, which is essential to the non-waivable. No court has the ability to amend or deviate from the obligations required under the Act. Ukiah also, our statute requires us to try to follow the laws, the cases of other jurisdictions to make the law consistent with those jurisdictions. So there's no case that says otherwise. Those jurisdictions will say that multiple documents, including deeds that follow a declaration placed of record, working together with a declaration, constitute a common interest community. That's our argument, that the developer in this case, in fact, over time would transfer property to particular buyers and make it specifically subject to the declaration. In fact, in this particular instance, the declaration doesn't even have an obligation to pay assessments.
So
For the purposes of our case, we did not take this up because we felt that the courts probably would not spend a lot of time considering that issue. So in this case, for example, in your documents, there's a deed from Shoemaker Construction to the Belchers at AP 193. Here is an example where the developer specifically made the lot subject to the declaration.
So in the petitioner's brief, you specifically state that the insufficient property description means that Falcon Ridge cannot be sustained as a valid or lawful common interest community under the Uniform Act. But in your reply, you state no one in this case disputes the existence of the Falcon Ridge Declaration. What's
Yeah.
your position?
So my position is that that declaration alone fails. Our position also is that as the developer transferred lots by deeds, making subject to the declaration, that to the extent that those deeds, those lots were made subject to the declaration, that those lots constitute a common interest community. What they don't include are the lots that my client acquired that are specifically not subject to the declaration. And that's case law out of Nevada and Colorado
So
and
you're
other Ukiah
basically saying the
states.
declaration is ambiguous and you have to use extrinsic evidence in order to determine what the actual intent of the declaration is, correct?
No, Judge, that is not what we're saying. The
Well,
case law is pretty clear that if
If
a
it fails, then it fails, and there is no declaration.
Well,
But
if
you're
it-
saying there is a declaration.
If a declaration is filed without further conveyances made subject to it, it is not a common interest community. Once a lot is made subject, one lot is made subject to a declaration and an obligation to pay assessments, then yes, there is a common interest community, albeit of one lot. In this case, there were multiple lots that were made specifically subject to it. We didn't take that position below. We noted that the declaration alone, standing alone, fails to create a common interest community in that sense. So the failure to include references to this Plat 6995, which is found in your documents at AP 193, would show that there is no reference to the lots that would allow any court to make a distinction about which among those creates the common interest community. We stand by very deeply that the deeds that my clients acquired, these properties, there are more than 40. Somehow the lower court only decided that 6 would be made subject among those 40. But our case law and says specifically where the court is determining whether lots are subject to planned community servitudes. Again, Ukiah's provisions cannot be waived. This was a holding in Justice Holdings, LLC versus Glade Springs Village of our Supreme Court. And I would like the court specifically to refer to, for its benefit, Section 2.1 of the Restatement Third Property Servitudes, which specifically discusses how servitudes are created in our world today. A servitude is created if the owner of the property to be burdened enters into a contract or makes a conveyance intended to create a servitude that complies with the statute of frauds. That doesn't not happen here. In fact, the court relied on a unrecorded brochure, marketing brochure, that there is no evidence in the record that my client had any notice of, and does not specifically discuss which lots are made subject to a servitude, nor does the brochure even talk about the obligation to pay an assessment. The Restatement 2.7 also says of the same servitudes provisions that the former requirements for creation of a servitude are the same as those required for creation of estate and land. And our own statute of frauds talks about creating an estate and land shall be created by deed or by will. The last is that the lower court's decision is fraught with just injustice and inequity. There was another party in this case, Crazy Mountain Cycles, who acquired its number of lots by basically the same kind of deed, same style of deed that did not include a provision making their lot subject to the declaration. And the HOA immediately agreed that those lots would not be made subject to the declaration.
How does your position reconcile with the Supreme Court's general plan doctrine in Jubb versus Letterly?
Literally, I think, first of all, I read that a little bit more closely. It doesn't specifically say it's a common interest community. It talks about restrictive covenants, number one. So I can't tell from that case whether it's a common interest community. In fact, this court probably can't rely on it for that reason. Assuming that it was one, I think it's been abrogated. I don't think that that is good law in the context of Ukiah. But this court can distinguish between that case and this case because intent has really little bearing on this issue. It is what do the documents constitute. The case in Justice Holdings versus Glade Springs made it very clear we don't care one bit about this intent. It's what do the documents say to comprise or constitute a common interest community.
Mr. Sad, you've used 15 minutes.
Thank you, Your Honor. I'll take one more minute for that and talk about 36-3-11. That statute does not apply to this case both by its own elements and both by the remedy that it provides. The elements of that case do not apply to this case, and the remedy in that statute is not available, does not include divestiture of title so even assuming that my client's case is subject to the facts or the elements of that statute, it is inapplicable to this case.
What do you mean by the elements don't apply? Are you saying it's not a corrective deed at all under that statute?
It is not, Your Honor. In fact, the property cited, Lot 94, was a division of the property, albeit a very inartful one. It attempted to say one half is retained by the HOA and one half was conveyed to my clients. It's not even applicable under element A. And element B and C are completely not applicable because they don't apply. The error is not apparent by reference to other information on the face of the deed.
So your argument is this isn't a corrective deed at all, it's just a deed.
It's just a deed. It is just a deed. Thank you, Your Honor. I'll reserve the rest of my time.
Thank you.
Thank you.
Mr. Walters, you have 20 minutes.
Thank you, Chief Judge. Thank you, Chief Judge, and may it please the court. My name is Ron Walters. I represent Falcon Ridge Homeowners Association, the respondents in this matter. Your Honors, I believe that the court should affirm the lower court's decision. As this court has discussed at length, the lower court's order was noticed, heard, the parties argued, presented evidence.
Counsel, was a bench trial held in this case?
Well, Your Honor, I think in actuality, yes. I would argue that it did occur insofar as the parties presented essentially it was a bench trial and everything but name, Judge. And in actuality, the court heard the arguments of the party, took them under advisement, saw the evidence in this case, and made a determination, made a declaratory judgment determination.
If it's a bench trial and everything but name, is that important? If something is noticed as a summary judgment hearing and it morphs into the court ends up taking evidence and making factual determinations without it being noticed as such, is that proper?
Well, Your Honor, I don't believe that there was any objection by either party to that occurring. And I think that's important here. If you don't properly preserve the objection below, the parties were aware of what the court was doing, did not object to it, I think essentially turning this into an impromptu bench trial and making a ruling specifically on findings of fact and conclusions of law as those are applied to the facts in this case. All that being said, I think that had the effect of rendering this a bench trial. And then the appropriate appellate review here would be to give deference to the lower court on its finding of facts and conclusions of law.
Can you identify from the public record alone how one determines which 49 units were included in the planned community?
From the public record alone, Your Honor, we admit that Schedule 1A, which presumably would have given us that specific, there's nothing filed in the clerk's office or the county clerk's office that would, I think, give you that fundamental discrete amount of that property, or identify those 49 units. However, it's replete throughout the public record, and also evidence was adduced here below that the underlying intention of the parties was to develop a specified area of the larger area that was deeded to Falcon Ridge from Shoemaker. That being said, judges, I think that leads us into the Jube argument, which fundamentally the court applied Jube versus Letterly, and I may be mispronouncing that, but I believe that's based on my reading how it's said. Jube versus Letterly to these facts and circumstances, that when fundamentally the deed itself or the conveyance itself, declaration fails, that we need to look to the intention of the parties. And that's reaffirmed in Tays Valley. Tays Valley Owners Association versus Cottrell. And it's when all tangible indicia of the legal status of property and the application of restrictive covenants failed to provide a resolution, attention must be shifted to the original intention of the parties. And I think the evidence that my clients put forward in the court below, and certainly the court below agreed, was sufficient enough to establish the intention of the parties, to establish these 49 units, which are inclusive of the petitioner's portions of this property, would be part of that declaration. And I think the declaration itself, in reading it, goes broader than that to say that it actually reserves the right to expand into other areas ultimately. So I think that,
Does that meet, I was wondering about that because it does, it says 49, but we may get more. Does that meet the requirement that the maximum number must be stated? Because if it's 49 plus, that doesn't seem like a maximum number.
well, sure. And I think it would be difficult to comply with the strictures of the statute sometimes when the question of further development in an area is going to be undertaken. So I would argue that it does at that time, and as the that reservation of rights essentially within the property bounds says, we have a right to determine that. Now, I think the Supreme Court, UCI was initially enacted in 1980. The Jube.
It was just condominiums in 1980, wasn't it? Wasn't the community, the more subdivision, I'll call it a subdivision. I don't know if that's the right term or not, but wasn't that added in 1986?
It was, Judge.
Or 84 maybe, I can't remember.
I think
which.
84. It was in the 80s. I can't recall right off the top of my head, but essentially, Judge, Chief Judge, UCI was in effect when Jube was decided. And I think that's the thrust of this. The Supreme Court had the ability to look at UCI.
Well, when it was decided, wasn't it just the condominium? Jube was early 80s, right?
I believe.
Oh, 91, excuse me. It was, but the land was developed in the early 80s. When this was developed, it was before Ukiah, correct?
Falcon Ridge was, yes, Your Honor. Yeah, so, and specifically, but when the Supreme Court had the decision before them and the issues before them, Ukiah was enforced, Judge, and certainly the Supreme Court could have said that Ukiah controlled. They instead said, when Ukiah fails, when there's a fundamental issue, and much like, and Jube is very analogous here in the sense that.
Point me to that in Jube, though, where it specifically talks about if Ukiah fails, this is what we do.
Well, no, it doesn't say that, Judge. I'm inferring, I think.
Okay.
Purely
Fair
from the perspective of the Supreme Court had that at its.
I got you. I understand your argument.
And ultimately said, hey, we're going to go a different way in interpreting restrictions and covenants and how they apply to these owners. And it comes back again to the intention of the parties and the creation. And I think there has to be a fail stop because I don't believe that Ukiah stands for the proposition that ultimately if you're deficient under that 105A3, which is the legal description of the land, or if you're deficient in any one of those regards, that it completely fails. I think that, from a perspective, the court said, hey, what happens when it doesn't meet those specifics? And in Jube, it didn't give a legal description of the land specifically. It was a planned community, essentially, and it didn't give a specific, but also there were deeds that were conveyed in Jube which did not contain the restrictive covenants explicitly within the deed. So, or reference to the declaration of explicit covenants. So I think Jube controls. I think Jube here would dictate that essentially it's the intention of the parties and the courts must look to the intention of the parties, which kind of in a roundabout way brings me back to the first argument that here the court did in fact look to the intention of the parties. Now, it may not have been the Bellomys, but obviously within the history of the land moves through multiple parties' hands. And as it moves through multiple parties' hands, the understandings of those parties are important for, at the time of the formation, the respective positions of the owners in that property. And look, the fundamental truth here is that everybody else in this community understands this to be a common interest owners association.
Was that, I mean, was there testimony adduced? Did you get witnesses live under oath?
Your Honor, I'm going to be honest with you, I was not counsel below, so I don't know from the record, and I'm just going off the record that was adduced by the petitioners in this. I don't know if there was testimony taken specifically. I know that evidence was discussed. But the court here, again, felt based off of this record, Your Honor, before us, and the order that it was appropriate to undertake a bench trial. Again, as I understand it, there were no objections to conduct that as essentially a bench trial. But fundamentally, I think, again, it reverts back to this situation. If Ukiah fails or a party fails in the face of Ukiah, that ultimately the intention of the party should govern. I mean, I think that's comports with our standard understandings of almost all contract law, that the intention of the parties is ultimately what governs. Respondents raise here that this was improper parole evidence. But again, when weighing that Jubb decision and looking to the intention of the parties, that evidence, I think, is not only appropriate, but absolutely necessary to develop the intention of the parties in forming this fundamental.
So are you arguing there's ambiguity in it, or are you arguing there's no ambiguity?
In the declaration?
In the deeds and the declaration?
Well, Your Honor, so what I would say is there's certainly ambiguity from the perspective of that there was no, for instance, Schedule A1 was left off. Some of these deeds were conveyed without restrictive covenants directly in them. But I believe that there's no ambiguity to the extent, there's no ambiguity to the extent of the intent of the parties.
How is somebody that's buying one of these lots that's in that area, how are they supposed to know whether they're buying one subject to the declaration or not if those restrictions aren't in the deeds? I'm purchasing one. How am I supposed to know?
Sure. I'd say at least two ways, Judge. First is a title search. A fundamental title search of the area would produce.
But we don't know which 49 lots are in and out, so what good is that going to do me? It might show me where my lot is, but there's nothing to tell me what are the 49 lots, so how does that get me there?
I agree, Your Honor, therein lies a little ambiguity, okay? And I think that's where the latter part of the inquiry comes in, is what is the intention of the parties and even the history of the area. I think a standard inquiry of a party selling a land who clearly is part of a neighborhood like this could reasonably inquire as to whether or not this, hey, we conducted a title search, we found this declaration that says Falcon Ridge on it, there's a big sign on the way in that says Falcon Ridge on this, does this apply to me? And I think those types of questions, again, goes back to the fundamental intention of the parties and what the historical relationship has been. These 49 lots, while there is ambiguity as to which, the specific areas of it, again, and that's a failure to attach that A1. But again, reading that, I think, says, look, we can expand it outwards, and there's some issues. So again, I think we ultimately fall back to Jube, which would say, hey, look to the intention of the parties to see, how this is applied to the parties. As to Lot 49, Your Honors, and specifically the statute 36-311, I think that this corrective deed fails on its face.
What authority supports invalidation of a corrective deed that fails to comply with 36-311?
I think the statute alone, states very clearly what the steps are that need to be taken. Now, the court's authority to invalidate that deed in and of itself, I think, lies in the circuit court's powers, statutory powers to.
But it's not in the statute. There's nothing that says that if it doesn't, that the court should invalidate a corrective deed, not a corrective affidavit, right?
Yes, Your Honor. So a corrective deed in and of itself, I think the petitioners take the position that it's just a deed. But in that, I guess leads me to the position that in 2007, that the western portion of Lot 94, and Lot 94 has somewhat of a tortuous history insofar it did not follow the exact plan originally. It's now reconstructed. The western portion and the residue, the western portion of that lot was conveyed to Falcon Ridge as a common area owned by Falcon Ridge. It was accepting and reserving the remainder to the Shoemakers. The Shoemakers then deeded that. Well, they failed to include specifically in the description, the legal description of the land, Lot 94, in the deed originally to the Bellomys. They undertook a corrective deed, titled corrective deed. I think fundamentally it should follow that statute step by step as to exact steps that should be undertaken. And I think it's well within the court's power to then determine that deed fails. And
Did the circuit court's ruling regarding Lot 94 extend beyond the portion conveyed in 2007?
I don't believe it did, Judge. I think that the western side always remained with Falcon Ridge. And the eastern portion, I think it was just the eastern portion of the residue that would have been invalidated essentially by the circuit court's ruling. I definitely could look back at the order, but from my recollection, Judge, that's where it invalidated. So
So it's your position that the circuit court's ruling just basically based its ruling on the 2007 deed?
well, and I think also, Judge, the failure to comply with the statutory requirements of a corrective deed as well. But as to the western portion, I think that's securely within the respondent's possession insofar as the 2007 deed.
But so just help me explain. Did the circuit court state that the portion that wasn't in the 2007 deed, did that order state that Falcon Ridge owned that, or is it saying that Falcon Ridge only owns the portion that's in the 2007 deed?
Well, Your Honor, I would say that it's, I'm trying to recall from the order, Judge, insofar as, I think the 2007 deed stands on its own to establish the ownership of Falcon Ridge, of parcel 94, or rather Lot 94 as to that western and that right-of-way or expanded road as it states. I don't believe that the order ordered that, and I'd have to look back, Judge. I can't recall directly from memory. I know it can concern the eastern portion of that, but I can't recall exactly what the order said.
The legal significance of a corrective deed as opposed to a regular deed is, as I understand it, is if you follow the formalities of the statute and have a corrective deed, it relates back to the date of the original deed.
It
correct?
does, as I understand it, Judge, yes.
And so I guess my question is, if you have some deed that says in its title, corrective deed, but it doesn't meet the formalities, so we're not getting relation back. I think that's clear. Without dotting the i's and crossing the t's, we don't get relation back. But why wouldn't that just be construed then as a regular deed? It's clearly as an intent to transfer whatever property is still there. It's not meeting the formalities of the statute, so it can't relate back. But why wouldn't it, from the date of that deed, transfer the property that it purports to transfer?
Well, Your Honor, to the extent that if this court finds that it is just a deed by itself on its face and it intends to transfer that residue of Lot 94, then I think it could stand on its own. It's certainly not what the lower court, as I understood it, did, but.
Well, I agree. I don't think it.
Yeah.
We can agree on that. I don't think it is what the court did.
And I don't want to speak, again, I have to recall back precisely what the verbiage was, but again, if this court finds that that is a conveyance insofar as a deed and it stands on its own two legs as just a deed, albeit one that is inartful and somewhat conflates the two, obviously, as such a correct deed, I would imagine that would be certainly one way. But the lower court went ahead and took the position that this failed by purposes
If
of
it
the
did,
statute.
would those parcels be subject, under your interpretation, would those parcels be subject to the restrictive covenants?
It would, Your Honor. I believe that it would. I think that it still falls under the original intention of the parties that that area be part of the, specifically, I guess my question is are you talking about Lot 94, the eastern portion?
The portion, I mean, obviously, you can't convey stuff that's already been conveyed, right? So,
Yes, Your Honor.
yeah, so Falcon Ridge owns western portion. I assume that Petitioner's Counsel doesn't dispute that, but I'll ask him. But the portion that, if the court were to say that the deed, the corrective deed, which might be considered a deed, would that be considered, would that be subject to the restrictive portion?
I believe that it would, Your Honor. I think that based off of the long-term intention of the parties, and I should, I want to hedge just a little bit, Your Honor, in that so far as I don't know specifically if the eastern portion of Lot 94 came up below and was discussed at length. But if, I'll say this, if there was a long-term position, I know that the western portion, it was generally treated as almost a nature park for the community. It was regularly held for picnics. The signage for it was treated generally as a common area. So if the eastern portion is like in kind in treatment, I would say that it does fall under the common areas, or excuse me, the constraint confines of the declaration, Your Honor. So, and I believe that it can be well established from the intention of the parties that that area was also within the bounds of those 49 original lots.
Let me just going back to the applicability of the declarations generally and moving even away from the specific lots in this case. But we're still in a situation where the 49 lots aren't described anywhere of record. So if there's a dispute about any of those lots and the parties are disputing whether they're subject to the declarations or not, is the remedy now you'd say, well, let's all just go to court and you put on your evidence whether it's intended to be part of this and I'll put on mine evidence of whether it's intended to be part of this, and however it comes out, that's how it comes out until we get to 49 and then we know we're done? I mean, is that how we do this?
Well, in crafting a solution, I believe that the Supreme Court ultimately said there's going to be ambiguities in property conveyances. Mistakes are going to be made, things are going to be left off. And when we have those instances, or areas are not going to be particularly defined, I mean, I think under the best circumstances, and in a perfect world, we're going to, specify exactly what areas are in the.
Well, sure, and that's what the statute contemplates in an ideal world.
Yeah, and certainly statutes contemplate, doing it, a specific way to avoid those conflicts. And I think that's ultimately the thrust of the statute. Hey, look, to avoid these, but if we come back to a fail-safe and we don't know what it is, we may have to resort to the courts to make that determination, and that comes back to the fundamental intention of the parties. We have contract cases, despite well-established law on how to establish a contract all the time, and I can certainly understand the court's concern that in crafting a solution, it may not be perfect to address all issues at all times. But I would say that given ambiguities in a declaration or in a grant under a deed, that ultimately we probably will have to come in and determine what the intention of the parties were to determine specifically how it's treated.
Does the UCIOA, I'm not even going to try to pronounce it like Mr. Satt, require strict compliance with its description requirement?
Well, I would say that specifically ICA, and I believe that's how Mr. Satt, I'll defer to Mr. Satt on the appropriate, he's far more familiar with it. Under 36B-2-105A3, it states a legally sufficient description of the real estate included in the common interest community. Oh, goodness. He had referenced, I believe, and I certainly don't want to misstate his references, another section which essentially said that the parties cannot abrogate the rights underneath that statute by agreement. One second, Judge. But specifically, I think that I don't want to say that it's strict. I think it's a legally sufficient declaration of the specific area. under 105. Again, it's a legally sufficient description of the real estate included in the common interest community. I know that legally sufficient description in and of itself, I think, can be interpreted several ways. But again, I mean, we admit that the declaration failed to attach that Schedule 1A.
I think you've gone past your time. I think we understand your position.
Sorry, Judge. Thank you.
And actually, Mr. Sadler, you're back to 5 minutes because we were generous with Mr. Walters, so you have 5 minutes.
Thank you, Chief Judge. I'm looking at the orders, and they specifically refer to the parties came before this court for a hearing on the parties' respective motions for declaratory judgment. Both orders. So I just reject that there was a trial. There wasn't. There was argument. There was no evidence taken. There was no testimony. It was just simply colloquy between the court.
Counsel, do you, we talked about the western portion. Do you object to the fact that the Falcon Ridge owns the western portion, which was conveyed in 2007, or do you?
No, Your Honor. In fact, I hope our pleadings were pretty clear that this statute's not even applicable on any of its elements, A, B, and C, the first not even being met because it's not referring to a unit located on Plat 6995. It's literally talking about a unit that has been divided somehow inartfully by the parties. I also pivot to, I think it's my assignment number 9, which talks about burden of proof. Courts don't talk about this much anymore, and I don't understand why. The burden was on the HOA to come forward and explain how it owns the sign and how it owns the lot. There's no surveying testimony. There's no location of the boundaries. Nothing in the record. This court cannot rule in favor of a statement that somehow Lot 94 has clearly been stated as proof to its corners and to its ownership. There's nothing in the record to even establish that. So how I would ask the court to please place the burden of proof on the HOA, which brought this case on that point.
So I just want to clarify. The 2007 deed seems to say that the western portion is conveyed to Falcon Ridge.
Judge, it was not in dispute in this case.
Okay.
It was the HOA that brought in dispute the other portion that was
Okay,
conveyed to
okay,
my
just-
client.
okay. I
Therefore,
couldn't
as
understand
Chief Judge
basically.
Clear was saying, Your Honor, as he was saying, this isn't the deed of correction, it's just a deed. And it was effective as the date of the second deed, the transfer of the. Not only that, so the statute was used by the lower court and argued by the HOA that somehow my client's rights of access, which were granted in both deeds, were somehow divested by the fact that this statute wasn't followed, where the statute doesn't even apply to vested rights of way. So it's not even applicable in any remote sense of the word. So this court enters an order that in the last minute, the Rule 59 order says, oh, by the way, you don't own your rights of way anymore to all of these lots that you paid valuable consideration. It wasn't pled in this case. It wasn't argued in this case. It was just simply briefed.
Which specific streets and roads are you claiming were not a part of the conveyance in the 2007?
It's all of the deeds and the streets that are reserved by the declarant in its reserved.
Do you not know which actual streets?
Yes, but let me be very clear. This does not preclude the use by the HOA and its members of those streets. They both have non-exclusive use. It just so happens that the Bellomys own the land beneath it and the right of access to their rear lots, while the HOA has its rights of use of those same streets that were directly
So
granted
your client
to the
didn't put
HOA.
up any fence on the streets? Where did your client put the fence up?
Not to my recollection. No. We're talking about fencing around their property.
But not in the
The
streets?
streets were not barred to my, now, streets behind the HOA, yes, because they owned the land behind the HOA's rights to use those streets. And the streets were declared as such in the declaration itself, treated as common property. And notably, the sign and Lot 94 were not noted as being part of the common properties in that declaration. This is an important factual point that we should discuss. I do appreciate this discussion about Jubb v. Letterly. I think this court can distinguish it quite easily. I have no idea whether that was a common interest community. Mr. Walters referred to it as one. I don't believe it was referred to one by the court in that case. And so I don't think it's applicable because I refer you back to my very first statement. What is a common interest community? I don't see it in Jubb v. Letterly. Intent.
Let me ask you about, as I understand the facts of Jubb, that community, to the extent a common interest community existed, it was developed in the early 80s, which would have been prior to this statute.
That's correct, Your Honor.
So-
The
so
case was in
whether-
92.
So whether the common interest community existed would not, in that case, would not have been subject to this statute.
That's correct, Your Honor.
And in this case, the development, if it occurred after the statute.
Yes. I implore this court to focus on this issue of intent. As the court in Justice Holdings, the Supreme Court said, the intent doesn't matter. It's strict compliance with the act, and this act is an act that's been adopted either as a UCA or UKIOWA in 19 different states. And the case law is uniformly that if you do not follow the act, then it fails. And the court will try, as it should, to assemble documents in the record to demonstrate that one or more instruments, including multiple deeds that have been made subject to the declaration, constitute a common interest community. If a developer is now going to be found by the intent of the parties that somehow lots reserved are not put into play, that's going to cause havoc with the entire industry.
What specific prejudice resulted from the circuit court's property analysis?
In terms of what your judge?
What specific, in the order, with regard to how the lower court treated the property, what's the specific prejudice that resulted for your client from that?
My client's property has been made subject to assessments and use restrictions that no one ever had the intention of placing them under. The developer and lawyers hired by the HOA itself said they weren't subject.
So your prejudice is the assessments. Okay.
Yes, and not only that, the deprivation or divestiture of title to their streets and roads for public access were divested because of this reliance on 3611.3, and plus.
I think we understand your position.
Thank you,
and the case
thank
will
you,
be
Judge.
submitted.
All right, remain standing while the judges leave the room. We'll be in a brief recess.
Please call the next case.
First on the Rule 19 docket, Jewell R. Hughey versus James M. Cagle, individually and as partner in the firm of Cagle and Jackson, and Cagle and Jackson, case number 25 ICA 316, and Jewell R. Hughey versus Rodney Jackson, case number 25 ICA 317. Judge Daniel W. Greer voluntarily recused. The Honorable Judge Deborah McLaughlin, sitting by temporary assignment.
We'd like to welcome Judge McLaughlin for joining us, coming all the way from the Eastern Panhandle. This case is set for a Rule 19 argument for 15 minutes per side. Petitioner, would you like to reserve any time for rebuttal? 5 minutes. Okay. You may proceed.
Thank you, Your Honors. May it please the court, I represent Jewell Hughey. The court is familiar with this case as it's been appealed here once before and sent back to the trial court. We're here today asking this court to reverse a refusal or denial of a motion to amend, the granting of a motion for summary judgment, and the vacation and the dissolution of a permanent injunction that was issued by order dated July 8. The court has all the documents that have been filed, but I think it's important at this point to address the constitutional issues that have been raised in our submissions. The first one's the issue regarding sealing. In both cases, the court entered an order sealing the entirety of the file without making any findings, without making any conclusions, just a very broad, we're sealing this file and nobody can see it, nobody can look at it. Even counsel had to get special permission to be able to look at the file. And in fact, until I believe late in this proceeding, after this court sent the Jackson case back to the trial court, the judge never allowed us to have unfettered access. It always had to come with a permission slip that had to be taken to her, and then you might be allowed to look at the file. It took some time on occasion to get those, but you couldn't do anything. And on the sealing issue, this court's well aware, pursuant to Garden State versus Hoke, that the court has to make certain findings to seal a file. One, she has to analyze whether the order meets a compelling interest or need. That was never done. Number two, whether it was narrowly tailored to meet that need. Again, not done. And three, whether there was a less restrictive alternative. I would suggest that simply sealing a file in its entirety is not the least restrictive means. My client produced, I believe, 4 or 5 volumes of documents with attached lists of documents she maintained in this case. I don't think there's much argument, but the vast majority of those documents have no privilege whatsoever.
Was your client not able to look at the documents? I mean, it looks like on the record that your client might have been able to look at it before the hearing on 5/1/25. Was your client not able to look at the documents prior to that? Is that what you're?
No, Your Honor. Prior to that, we weren't allowed to look at the documents unless we had permission from the court. Nobody had access. I couldn't call the court and ask for a particular document as Ms. Hughey's counsel. I had to actually get a permission slip and have it delivered to Judge Bailey, and then she would tell me whether and when I could look at those documents. So it did provide a problem. The other thing it did, it prevented us from being able to develop evidence. You know, we couldn't interview witnesses because if I utilize a document with a potential witness, then I violated the sealing order. So you couldn't obtain evidence. You couldn't challenge the opposing party's claims. You know, we were simply, Ms. Hughey was simply prohibited from being able to use any document in that case with other witnesses. And frankly, Your Honor, I believe that violates Article 10 due process, Article 3, Section 10 due process, and Article 3, Section 17 with regard to the open courts. And I think that's pretty clear. I think there were less restrictive means. I think the court could have actually looked at the documents that were submitted by Ms. Hughey in 2018 and made a determination as to whether there was any protection or not afforded to those documents. Nobody, to my knowledge, in the, I guess, 7, nearly 8 years since she filed those volumes of documents in 2018 have addressed whether there's a protection to them, who they belong to. The original issue in the case, the underlying case, the old case, the Cagle case, was what documents she had. What spurred that whole thing was a complaint for injunction that was filed to determine what documents she had, and that's what the court said that the matter would be limited to at that time. Mr. Cagle's counsel was allowed to depose my client. We weren't allowed to depose anyone else. There were subpoenas issued for hearings. There were motions to quash, and I believe the subpoenas were quashed. So at every twist and turn, she was denied her opportunity to provide a meaningful defense to the original claim. After you get to that, the
Counsel,
second. Yes.
where in your assignments of error do you raise the due process on the circuit court's issuance of an order sealing the?
Your Honor, I don't believe it was in a specific assignment of error. I believe it was in the reply.
Okay.
And I believe that constitutional issues can be raised for the first time before this court, particularly the issue of standing.
But if it's in a reply, how did the respondent have an opportunity to provide the court its judgment on the matter?
I believe it was in regard to the fact that no discovery was allowed in the case, and they addressed that in response to our argument, and we submitted that argument as a reply to theirs. And to be candid, it might be, the court may not like this answer, but and it could be a failing on my part. But I believe it doesn't matter at what stage in the proceedings. And I understand what the court's saying. How could they respond to it? They could have filed a motion asking the court for an opportunity to respond to the reply.
Well, let me tell you what the court did with the concerns you raised before the reply brief, which is we clearly made the order on appeal not subject to the seal, so that the public could see what the matters were that were before this court, so that we could be reviewed by the public and be an open appellate court. I guess I don't feel comfortable holding having a long discussion on matters not within the assignments of error. So I would recommend you turn to those, even though I understand you're raising this constitutional issue.
Well, and the next issue, Your Honor, would be standing. And that's with regard to the injunction. And it's our position that the West Virginia Attorney General is the proper party to assert arguments for injunctive relief in this particular litigation. They were the lead trial counsel. They were the one bringing the litigation. And I think as the Attorney General hiring outside counsel, they have a duty and an obligation to manage and supervise the file. And they have to approve or be involved in actions that relate back to, in this case, the opioid litigation. And that was never done. And I think, Mr. Sadd had an argument up here about, remember the burden of proof. The burden of proof is on the plaintiff to establish that they have standing to assert the argument they're making. And I don't think that the respondent in this case had standing to assert those claims. The privileges and the documents and the protections belong to the Attorney General as the lead counsel in the case.
But that standing argument would not apply. That also was not an assignment of error specifically, although certainly you did challenge the granting of a permanent injunction in the final order. I'm a little confused. I thought there were a number of different types of cases, not just the state opiate litigation, but there were other private cases that were pending and were decided and were lumped in as part of the engagement of your client. So do you allege that the lawyers in this case didn't have standing to assert and to try to protect their client's interest in their own work product?
There were two types of cases. There were Mingo County cases, which I believe Mr. Cagle handled in its entirety. There were the Boone County cases, which are primarily the ones that the documents are about in the pleadings, because there are certain documents from Boone County that have been alleged to have been confidential or highly confidential, and that was the reason the file had to be sealed. The unfortunate truth was most of the documents were never sealed, or as to those that were sealed, Attorney Cagle filed a motion to unseal those documents, and the court unsealed the documents, which let out all the pharmaceutical information that was really the crux of the privileged information in the underlying case. So, you get into this issue of, and again, back to the injunction, you get to this issue, at the end of the day, the court still has to determine irreparable harm.
Counsel, I want to move over to your claim that the motion to amend was improperly denied. On your client's position as to quantum merit and unjust enrichment, what are you seeking there? Are you seeking the percentage that's in the contract, or what's the relief you're seeking?
No, I think under Simone, if the fee-sharing agreement is invalid, then you have to look back to what what contracts or what basis she would have for the work she did for counsel.
But she was paid that. She was paid
Yeah.
that.
How much
right?
was she paid? How
She
much?
she was paid, I believe, around $48,000 a year. She had left a job at Bailey and Wyant making close to $100,000 a year, and she was also allowed to work for other companies. So I mean, she entered into the contract with the respondents that obviously had the 10% bonus, which I think the court, rightfully struck as a fee-sharing agreement, an improper fee-sharing agreement. But then I think if you throw out the contract, then you have to look back as to what the parties did prior to the issuance of that contract, because I think that can form the basis of that claim going forward.
Okay, you've got done 10 minutes, so if you would like to keep your 5.
Thank you.
Counsel, you may proceed.
May it please the court, my name's Janine Legato, and I represent James Cagle, Rodney Jackson, and Cagle and Jackson. Let me address the last question first with respect to the motion to amend and whether she was paid. The record reflects that she was paid, and we're talking about a time period of March 2012 through January 1, 2017, so approximately 3.5 years. She was paid $279,000, which is considerably more than the average rate of pay for any paralegal in the state of West Virginia, perhaps maybe even the nation. If you look at the National Bureau for Labor Statistics.
And
So
that's because she got paid one of those bonuses, right?
yes, that is correct. She did get paid one of those bonuses. That would be correct. But so if you're talking about quantum merit, though, certainly quantum merit has already been satisfied. He is arguing that he should have been allowed to file a motion to amend to add a quantum merit claim and also an unjust enrichment claim. Here's the problem with that. He filed the motion like around 6:30 p.m. the night before the hearing on the summary judgment motion. So we had no opportunity to respond to his motion to amend. It violates the trial court rules of giving that no motion can be filed within 48 hours. It also violates Rule 15 of the West Virginia Rules of Civil Procedure, which requires leave of court in order to file a motion to amend. So even if you set those things aside, this case boils down to the fact that this court nailed it. This court got it correct. He and I did not. The lower court did not. When this case was before the court the first time, the first go-around, and I understand only perhaps one judge, not the three of you.
Two of us.
But when it was before this court the last go-around, that also was on a motion to amend in tort claims. And the court in footnote 2 said, we have serious concerns regarding our holding in Rich v. Simone. And the court remanded the case back, and then the trial court told us that she wanted us to address that. We begrudgingly admitted that that is a concern. That's a legitimate concern. And it voids the contract.
Now, on the quantum merit amendment, in your brief, you claim that collateral estoppel applies. Did the circuit court hold this?
Circuit Court did not hold that collateral estoppel applies, but if you look at the
Did the original attempt to amend that the petitioner made include quantum merit or unjust enrichment?
It did not. It included other torts.
So explain how collateral estoppel applies when he didn't try to amend it the first time, please.
How collateral estoppel applies.
Yes.
I think it's on the basis of the same legal analysis. A better argument, though, if I could just pivot for a minute, Your Honor, if I could have the permission to pivot for a minute. If you look at the Rich v. Simone case, which was pointed out by this court the last time that this case was before this court, Rich v. Simone is almost identical to the facts of this case. And in Rich v. Simone, that started out as actually a federal civil suit in the Northern District of West Virginia.
But
Now-
it's really not identical, because in Rich v. Simone, didn't the person who was not the lawyer, didn't the original, the person who was a lawyer think he was a lawyer and therefore thought the actual agreement was legal, where in this case, the lawyer knew that the person was not a lawyer. So it's not exactly the same, correct?
Not exactly with respect to that point, but with respect to the analysis in Rich v. Simone, Simone didn't have as many obstacles to overcome as he does. Simone had already included the quantum merit claim, he had already included the unjust enrichment claim, and he had already included all of the torts that Mr. Krim had included that this court dismissed the last time this case was before it. And the Northern District Court said in analyzing Gaddy, which, by the way, he relies on in his brief to support that the court erred, in analyzing the Gaddy opinion, the Northern District said, you know, West Virginia Supreme Court has never made a ruling as to whether or not the rules of professional conduct are statements of law. And so they certified the question to the Supreme Court, and they said, based on what the Supreme Court says, will depend on whether or not his quantum merit and his unjust enrichment claim can survive. Exactly the argument he's making today. And the West Virginia Supreme Court in Rich v. Simone said, absolutely, the rules of professional conduct are statements of law, and if you violate Rule 5.4 regarding sharing of attorney fees, then it is void. The agreement is void, and you cannot, no claim can be brought pursuant to a void agreement, including quantum merit and unjust enrichment.
That's not how I read the case. I read the footnote that specifically stated that quantum merit, they were not going to invite the parties to allow for quantum merit to be decided in that case. So I read that as the Supreme Court punting on that specific issue. Why is that why is that footnote not applicable?
Rich v. Simone I would look for it, but I don't want to waste time. Rich v. Simone, when the court starts its analysis, it says the Northern District has certified a question to us, and it said, we kicked the can down the road on Gaddy, is how Rich v. Simone starts out in its legal analysis. Now we must address the issue. We must take it face on. And they did address it face on.
But they addressed the issue based on whether a contract is valid. In
Whether
my
it-
reading, they specifically punted on quantum merit.
No, the reason that this question was certified to the West Virginia Supreme Court by the Northern District was to determine whether or not the quantum merit and unjust enrichment case could exist.
The language in the case does not state that.
In Rich v. Simone or in
Yes,
Gaddy?
it specifically states that the actual language, it specifically states they're not going to do quantum merit because that was not included in the certified question in the Supreme Court.
That was my reading. And I think even just looking at the Gaddy case, there's no flag next to it saying it was reversed or overturned by.
No, it wasn't, because in Gaddy, the Supreme Court did not address the specific issue of whether the quantum merit claim could survive.
Well, in Gaddy, they affirmed the $75,000 under the quantum.
He had
merit.
already been paid.
Right.
As an expert witness. Well,
No.
as a, yeah.
Right,
fee.
approved
Well,
by the court under that theory of quantum merit.
Anyway, let's switch gears
Okay.
to the injunction. What would the permanent injunction that was granted bar the petitioner from utilizing the expertise she gained in working for respondent in a future agreement with a different law firm?
No, the permanent injunction would bar her from using any attorney-client privileged material. It would bar her from using any work product. It would, it certainly would not bar her knowledge, but what she was doing was she had a contract where she was attempting to solicit other attorneys, and in that contract, it stated that she had all of this information that she could acquire clients for, that she had the pleadings ready to go, that she had a PowerPoint presentation that she presented to an attorney in Mingo County. All of the things that she had, and she even had stated, and I think Debbie Priest had testified in one of the hearings, a witness, that she was present when she told one attorney, I have everything Jim Cagle has.
So why did the court not, in the permanent injunction, go in and figure out exactly what she had?
There was no way to know what she had because she stole that information.
Couldn't the court have had a hearing taking evidence as to what she had? I mean, that I read the preliminary injunction order, and it specifically, it sounded like it was going to do that at some point, but all of a sudden now the permanent injunction, it just states it's making it permanent without any evidentiary hearing. Why didn't the court do that?
Because there's no way to determine what she has. You would have to rely on her credibility, and she doesn't have much credibility in this case because.
Did
what
the
happened
court
to the
make
computer?
that finding that she was incredible and it couldn't determine that?
Well, if you look at the preliminary injunction, which the court adopted the specific findings of fact and conclusions of law in her final injunction, or final order, rather, she talks about how the emails were taken from Mr. Cagle's, disappeared from Mr. Cagle. Mr. Cagle lost a whole series, time period of emails, at which time she was no longer in the office but still had his password. The laptop that she had that contained all of the privileged information, which was protected also by court order, not just attorney work product and client privileged materials, but a court order protecting such materials, that laptop eventually, after a couple of hearings and numerous attempts to acquire the laptop through discovery, when that laptop was eventually turned over and taken to computer experts, the computer experts deemed that nothing could be retrieved from that. Ms. Priest testified that she had another witness in the case testified that Ms. Hughey had a thumb drive, a black thumb drive that contained everything in the state litigation case. And did she destroy that?
Well, the preliminary injunction is fundamentally different than a permanent injunction in this case by virtue of the findings in the preliminary injunction that require and could have been the subjects of contempt motions, et cetera, that require the conduct of discovery reasonably calculated to accomplish the foregoing, which would be accounting of all disclosures of information, all the information they had, gain reasonable access and assurance that they've been returned, deleted, or destroyed. I don't see you incorporate that into a permanent injunction. Every day you get to go do that again. You had a shot. You had a shot to get the information back or some assurance that it's back. Obviously, if there's ongoing violations proven, but there was no proof, independent proof, beyond the issuance of a preliminary injunction. And the preliminary injunction was an extraordinary remedy to limit material damage. And now it's converted to a permanent injunction that casts, a pall or maybe even a limitation on what somebody can do with their career. And I have a real problem with the court basically saying there is no contract and you're enjoined forever from engaging in activities where this thing in existence since 2017, you had the rights to go get it, had a court order to go get it, to get your assurance, to get it nailed down, and without any further evidence, that's carried on forever?
Your Honor, if you look at the rules of professional conduct, Rule 1.6, which prohibits the disclosure of all information obtained during your representation of a client, that duty extends to anyone that is in your employ or who works with you.
I fully understand
And
that.
then if you look at the case of Lawyer Disciplinary Board versus McGraw, that holding by the Supreme Court specifically states that it doesn't matter if this information later becomes public. If it was acquired by the attorney during the representation of the client, the attorney cannot use that information in any way without the client's permission. And that applies also to Ms. Hughey.
But couldn't that be handled with a future motion for contempt or some other?
Well, once the cat's out of the bag, the cat's out of the bag. I mean, you can't, no.
But you're enjoining something that you don't know what you're enjoining.
We're enjoining the use of any work product, any materials that she acquired through the opioid litigations in the state litigation case, and also in the Mingo County litigation case.
Well, isn't her argument, though, that some of that material is available out on the internet, the web that she acquired? So while she may have been working on a specific case, it's not information limited to that case. So is she enjoined from using that material?
I think that that's an excellent point. However, I think that the rules of professional conduct in the case that I referenced, the McGraw case, the Lawyer Disciplinary Board versus McGraw, would disagree with that point. Could she use that in a different manner because it's now public information? Possibly. Could she use it to solicit attorneys in a joint venture for a fee-sharing agreement like she's attempted to do in this case? No.
Well, we would hope no attorney would engage in that at this point.
I would too, Your Honor. The, fair point.
So you're specifically saying, let's reframe, are you saying that even though the language is very vague and broad, are you specifically saying that the injunction bars her from only sharing information that's subject to not being confidential pursuant to the rules of professional conduct, or does it go further than that?
Here's, because of her association with Jackson and Cagle, she had information that was privileged and confidential that she would have been able to then go solicit people to file additional claims. Now, that could possibly violate two criminal statutes, unlawful practice of law, and also there's, in the same Chapter 30, there's another that prohibits ambulance chasing.
But that wasn't brought up below, was it?
Yes, it was. And
It wasn't in the order, was it?
No. Yes, actually, I think it is in the injunction, Your Honor.
Not in the final order.
It references back to
It references back to the preliminary injunction. But, and before I forget, because Judge Lawrenson had mentioned it, you were talking about this being an extraordinary remedy, and I apologize to the court for my negligence this morning, because this morning is when it came to me, and I didn't have time to research it, but typically with extraordinary remedies, the intermediate court lacks jurisdiction, subject matter jurisdiction.
I did get clarified in 2024, and we've treated that as retroactive. We have jurisdiction over injunctions.
Over injunctions.
There are different kinds of extraordinary remedies we clearly do not have, but Chapter 5511 has been amended to clarify the extent of the extraordinary remedy limit on our jurisdiction. So
I apologize for not knowing that,
we
Your
would, we
Honor.
would sua
I
sponte
should-
bring that up. We're very conscious of not expanding our own territory, but we're okay with that.
Okay, counsel, your time is allotted.
Thank you.
I'm going to add another minute to Counsel Krim, just
I thought they each
even out the
had
time a
20
little bit.
minutes, though.
That's 15 minutes.
Okay, that's right.
You have about 6 minutes.
And just to address some of the last arguments that were made in response, the order that the trial court entered granting the permanent injunction is based on speculative damage. It's not based on actual and imminent damage, it's speculative. And I think our courts have routinely held that permanent injunctive relief is not appropriate for speculative injury. And that's what we have here. you know, when you look back at what's happened in this case, and contrary to what I think I heard, Ms. Hughey submitted to the court because the court had requested in the initial hearing in this case that maybe we can resolve all these issues by producing the documents. And so in June and October of 2018, Ms. Hughey produced affidavits with attached lists of everything that she had. And at no point, and I've raised this issue several times throughout these proceedings, at no point did anyone on behalf of the respondents or the court look through these documents and say X, Y, and Z are subject to work product. You know, A, B, and C are subject to protection in the Circuit Court of Boone County, because they simply weren't. And I'll also tell this court, in 2020, and I believe it's in the argument, but in 2020, Judge Polster, in the MDL opioid litigation, unsealed everything. Not just the pharmaceutical records that were obtained in Mingo and or Boone County, but even the internal data from the pharmaceutical carriers. So, you know, we're up here arguing, and I think the court astutely, you know, has suggested, how can you enter an order permanently enjoining her from using the information and knowledge she developed over the better part of 10 years of her career investigating these opioid, you know, claims. And you never go back and determine what she has, and you never look at how it's going to affect her prospectively. And she can't forget intentionally everything she's learned. And I don't know how you can have somebody that's been integrally involved in stuff and knows where certain filings or pleadings are that aren't sealed, that aren't under protection, that she can't go back and utilize that information. It's something that she gained on her own. And in fact, the entirety or the significant aspect of this is that the documents that she produced in large part were all things that she researched. Yes, she had apparently a void contract at this point, but a contract with the respondents beginning in June 2012. But she had worked on this stuff for years, and there's testimony ad nauseum from her as to the fact that a lot of the information that she had not that she was getting paid for by the respondents, but that she was doing on her own. And that's never addressed in the court's injunctive order either. I mean, if we're looking at the injunction, there simply are no findings that the trial court made that are adequate to permanently enjoin the petitioner from ever using any of these documents in future opioid litigation. The problem is, most of the opioid litigation's done now. It's over. You know, she didn't get her bonus. You know, she's been the subject of all these legal issues. She's been, you know, said that she's a criminal, that she's stolen documents. There's just no evidence. You know, the best evidence they have is Ms. Priest saying that she had a printout that said what the settlement amount was in her brother's case. And you have Mr. Simpkins who said, I saw pleadings. He couldn't even say they were pleadings from any case that the petitioner had worked on with Mr. Cagle's firm or the West Virginia Attorney General. Just had pleadings. Everything has been very vague. All the allegations are vague. You know, they talk about documents disappearing from Mr. Cagle's computer. Okay.
Counsel, let's go back to the quantum merit. The Respondents' Counsel states that she received $279,000 in compensation. What do you have an amount that you're saying that you think your client deserves over the $279,000 that you can say it is capable of being adjudicated by the lower court, or is it just?
I think, like in Gaddy, I think she should have an opportunity to go back and produce documents of the work that she's done. And from there, it's going to depend on whether she can get over $279,000. But the $279,000, remember, part of that was a bonus. Part of that was her monthly pay, which was about half of what she was getting at Bailey & Wyatt before she was induced to leave Bailey & Wyatt and work on this opioid litigation.
So does she have documents to document
My understanding
amount of time that she spent on all this?
My understanding is yes.
That she has time, that she was working on it but not being paid?
No, just tracking her time as to what she worked on. There was no, in their agreement, there was no set amount of time that she was supposed to work.
Well, she was allowed to work for other people, too.
She was, that's correct. And she had always done that. She had been working for Mr. Cagle, I believe, back into the 90s under oral, it was an oral agreement, but under the same or similar circumstances. She'd always freelanced and worked for a number of people.
And was she paid hourly or?
For Mr. Cagle?
Right.
Yes, to my knowledge she was, except for she did receive a fairly large bonus when the Mingo County case that Miss Priest's brother was involved in settled. And I believe the bonus in that case was 10%. So there's an established pattern and practice as to how she got paid and for what. But she was always allowed to work for other people, even under the 2012 contract. But unlike prior to 2012, she was no longer working at Bailey and Wyatt because they wanted her to come over and work on this litigation, even though she could do other things. So she gave up her salary.
Counsel, you're out of time. The case will be submitted.
Thank you.
All rise, remain standing while the judges leave the room. We have a brief recess. This court is again in session. You may be seated.
Thank you. Will the clerk call the next case, please?
Next up on the Rule 19 docket, Amber B. Elmore versus Mount Vernon Baptist Church et al., case number 25 ICA 234, an appeal from the Circuit Court of Putnam County.
This is a Rule 19 argument. The parties have 10 minutes each. Mr. Smith, would you like to reserve some time for rebuttal? How much would? You have 10 minutes. Okay, I'll notify you at 6 minutes. May begin.
Thank you. Your Honor, my name is Clint Smith. I represent the petitioner in this matter. On Mother's Day 2021, she was a Sunday school teacher for Mount Vernon Baptist Church. On that day, as her students were coming in, she asked them, did they love their mother, how they felt about their mother. Two children indicated that they loved their mother, and they, even though she hit them. And they liked her better because she didn't hit them as hard or as often as their father. The father happened to be a co-worker at the church. Following the class, Ms. Elmore told a deacon and the minister at the church about what had been disclosed and pointed out to them that they were all mandatory reporters and that they had to tell CPS about this disclosure. The minister, who would have been her boss, told her to not say anything, that there were going to be a meeting, there would be a meeting later that day, and they would discuss it with the coworker. That hearing or that meeting took place. It did not go well. Notwithstanding the instructions of the minister to not make the report, Ms. Elmore made the report, and later on, CPS and the state police, I believe, or maybe the sheriffs, went to the co-worker's house, and then amazingly enough, the children denied saying that they had told her that that the parents hit them or that they had ever hit them. Later on, there was a congregational meeting at a service in which the congregation was told that the deacons had decided to fire Miss Elmore because she could not get along with the coworkers. This action followed. This is a case of first impression in the state of West Virginia on several grounds. One of which is this is the first time you have an employment matter involving a church that also involves violation of a substantial public policy. It is the first.
How do we get around Gillespie that basically says even if a public policy argument had been made in that case, they couldn't have got to it?
Your Honor, I don't read it that way. I read it that.
Well, it says, more importantly, analysis of Ms. Gillespie's claims would, under either of these theories, meaning public policy, would require the civil courts to examine the reasons for the pastor's termination. Almost inevitably, this analysis will require the courts to go beyond complete neutral principles of law to inquire into church doctrine or to determine if the termination was arbitrary. This courts cannot do.
Your Honor, there is no need in this case for there to go beyond neutral policies, because what you have in here is the stated rationale for her discharge has nothing to do with doctrine. The stated reason in the statement given to the congregation when they voted on her discharge was she didn't get along with her coworkers. It wasn't a matter of she's not teaching the right things.
Okay, tell me where the ministerial exception is limited to that in any West Virginia or federal case.
It's not in any West Virginia case because it has never been addressed. If you look in Gillespie.
The ministerial exception comes from the United States Supreme Court. I mean, it comes from the United States Constitution, correct?
Correct.
And over the years since Gillespie, I read the federal cases to get stronger enforcing the ministerial exception, not weaker. Would you agree with that or disagree with that?
Particularly lately, I would say the courts are getting more protective of alleged religious exercise.
Can you point me to any of the federal cases decided on this that would create this exception if it's not specifically because she was teaching false doctrine, that that there can be a civil action maintained that doesn't fall within the ministerial exception?
Your Honor, I would look to Gillespie, because Gillespie specifically states that the civil courts don't have jurisdiction when you're talking about purely spiritual practice. And the civil court does when you're talking about property or contract matters. And that's what we're talking about here.
Can you
But-
distinguish these facts from Gillespie?
Yes. First off, Gillespie did not allege a violation of substantial public policy. You have two substantial public policies that are violated in this matter. One is the requirement of mandated reporters to report. And secondly, the substantial public policy that you don't hide criminal conduct. In this case, you have people who are hiding two forms of criminal conduct: their failure to report as mandated reporters, which is a crime, and the domestic battery on the children, which is also a crime. Because of those, you have substantial public policy. If you adopt the argument that is being made by the respondents here, a minister could, again, and it could have been the minister in this case that beat his children and refused to report it, and tell her not to report it and retaliate against her for reporting it. I believe if you look at the cases, there is no case that has had these kinds of facts where you're talking about hiding criminal conduct and hiding mandated reporting of child abuse, that a court has said, notwithstanding those facts, we're going to say that the church and the church members are immune.
How can a court evaluate alleged retaliatory motive without engaging in prohibited pretext analysis?
Well, in this case, you don't have to, because as it reported in the respondent's brief, there is the statement that I believe it was the minister gave as the reason why she was being discharged. And in that statement, there is nothing about doctrine.
I would disagree with that. If the statement is she's not getting along well with others, that's part of their doctrine, how they're supposed to get along with others. So, I mean, just because she doesn't quote a Bible verse doesn't mean it's not about doctrine. You've used more than your 4 minutes, actually. If you want to reserve time, you have about 3 minutes if you want to keep going, or you can reserve your time.
But, Your Honor, again, I believe Gillespie guides us here. It tells us no on the purely spiritual practices, yes on property contract rights. The congregational issue is appropriate. It says that judicial review is appropriate. It recognizes tort claims contrary to substantial public policy, and it also says there is a compelling reason to limit analysis on the vote, and that is because the people who gave the statement to the congregation withheld the information about the sexual harassment, without the criminal conduct in both committing the domestic battery and in the failure to report. If this court adopts that position, ministers and people in churches are blanket immune from being prosecuted or any kind of relief being granted for criminal behavior.
This doesn't have anything to do with being prosecuted criminally.
If you take their argument, it does.
No, it doesn't. No, it doesn't.
Yes, sir. Thank you.
Thank you.
Good afternoon. My name is Ashley French, and I represent the respondents in this case. May it please the court. This is well-settled law. While opposing counsel doesn't believe that it's been addressed in West Virginia, I completely disagree with that, and I read Rayburn more like the court has read Rayburn. Not only has the Supreme Court ruled that the ministerial exception would apply in this case, we also have the Gillespie case, the Eads case, the Chateauqua case, the Rayburn case, and others in other jurisdictions that would support our position.
Counsel, in Gillespie, the syllabus point reads, in a congregational church, the membership ultimately controls the business of the church, and without some compelling reason to do otherwise, this court will limit its analysis in a pastor's wrongful discharge action to inquiring whether the congregation met and whether it acted to terminate the pastor. Obviously, petitioner is saying there's some compelling reason otherwise. Why do you think this is not a compelling reason?
Well, the decision to terminate plaintiff's employment is protected by the ministerial exception and the First Amendment. The first inquiry is, was she a minister? And I think it's hard to dispute that she was because she made those concessions herself in the complaint. The next issue is, what is this wrongful termination case about? Is this about a contract? Or is this something that has been addressed by the ministerial exception, carving out the ability for churches to terminate someone without any court looking into pretextual reasons? In this case, the circuit court found that the exception applied. And then once you find that it applies, the next inquiry is, did the church actually meet, follow its bylaws? Did the congregation vote? I would submit that it's not just the church leadership that terminated plaintiff's employment. It was the actual congregation itself. They met on 2 consecutive Sundays. The vote was 51 to 16 with 2 abstaining. There's been no dispute that the process wasn't followed. And I think the fact that there were 16 that didn't vote to terminate her shows that reading the statement to the church prior to that, it wasn't just form. There was substance to that. And so the circuit court found that that's the only inquiry that was relevant at this time, and it dismissed the case.
So are you saying that there is no compelling reason?
There is no compelling reason.
And can you explain why? Because why?
Why there's a compelling reason?
Why there's not a compelling?
Why there's not a compelling reason to adopt plaintiff's position that a crime?
Without a compelling reason, otherwise, this court will limit its analysis in a pastor's wrongful discharge action to inquiring whether the congregation met and whether it acted to terminate. Why is his reason not compelling?
His reason isn't compelling because the law says that the ministerial exception applies unless it's a breach of contract, certain torts. It could be a different person, a non-ministerial employee who brings an action. It could be someone who's a member of the congregation. It's listed the compelling reasons, the reasons that a cause of action can go forward. Courts have already decided that race discrimination, disability discrimination, sex discrimination, wage payment type of actions, and public policy are the types of cases that are not compelling to look at weighing the risks of intervening and questioning a church's reasons for terminating someone. So they found in favor of the religious exemption and supporting that instead of allowing human rights claims to go forward instead. And that's actually been addressed in that way in the case law.
Okay, go ahead.
I hope I answered your question. I wasn't
Yes,
quite
I
sure
get
if that
it
was what you were asking.
Yes.
All right, so I also believe that we're losing sight of the remedies that was available to plaintiff. If she was concerned about child abuse, she took advantage of the remedy. She contacted multiple law enforcement agencies. She believes she was a mandatory reporter. That's not relevant, and the circuit court didn't find that relevant to this analysis. Yes, the church, mandatory reporters, but only if you have reasonable cause to suspect. And so that same day, as soon as the complaint was made, they went ahead and investigated it and met with the parishioners. Just because plaintiff disagreed didn't prevent her from being a mandatory reporter who contacted the law agencies. She did, so she took advantage of her ability to do that. She believed that she was being threatened and sought a protective order. That was her remedy. That was eventually struck down and not upheld, but she exercised her remedies under this. It's just so happened that if the court would say the ministerial exception doesn't apply, then it's going to have to look into why did she believe she had a reasonable cause to suspect child abuse? Why did the respondents believe that there wasn't reasonable cause to suspect child abuse? Why did the legal agency side with the respondent and didn't think that there was reason to escalate the claims. So again, like, that kind of thing isn't really relevant to me, but addressing some of his points, I think that it's clear. There's nothing that plaintiff has brought forward that is compelling as far as they believe the criminal action that should support a public policy. There's nothing here. If there would have been even child abuse found, maybe I could even see it a little bit more depending on the facts,
So
but that's not
I've
the
got
case
another
here.
question then, based on that. So is the ministerial exception categorical, or are there conceivable limits where compelling state interests are
Well,
implicated?
I think the public policy would have to be something that is already carved out as an exception, because the case law doesn't allow just anything to go through. It's already said there is no public policy exception to the ministerial exemption. So at this point, I think the Supreme Court has made it clear. It's the Supreme Court stating it,
So if
not
the-
me. I don't think public policy exception's there.
So if the church had said instead of saying what they said, if the church had said we're specifically terminating you in retaliation for what she did, are they immune under this doctrine, or are they not?
I don't think it's that clear cut. I think, I think that they are immune is the short answer there. But retaliation for doing something, not quite sure what the circumstances would be. I guess I would have to know more information. But I don't think they even had to list a reason of why they were terminating her. Their bylaws, their constitution doesn't require them to meet with the congregation and read them the list of reasons, an exhaustive list of any sort. It just requires them to meet and to address the congregation and let the congregation vote, which it did. So it followed its policy, and the congregation decided to terminate the plaintiff's employment, not just the Board of Deacons.
Now, when the meeting was held and whatever statement was read to the church, the statement that was read to the church was not a statement that we're retaliating this minister because she reported, correct? I mean, they didn't admit the allegation that's made by the plaintiff, correct?
That's correct, and that's why it's hard for me to really address Justice White's
And
argument.
so the plaintiff alleges that there's a real reason why she was terminated that's different than what they said. To get to the truth of that, the court would have to see whether their real reason was a pretext or not, right?
That's absolutely the case.
And that's exactly what Gillespie says we don't do. Is that right?
That's exactly right. And the other cases, the progeny of cases all say that the court cannot dive into the facts of pretext. It is not up to a jury to decide whether the reasons are good enough. It's not up to a judge to decide whether the reasons are good enough. It's not up to any fact finder to weigh whether the church made the right decision, not to second guess the church. And despite plaintiffs trying to bring in some kind of a fraud flavored claim here that facts were hidden from the congregation, I think is also irrelevant.
Are you aware of any cases in state or federal courts where exception to the ministerial alliance or ministerial exception was carved out because the facts weren't good enough given to the church at the congregational meeting?
No, I'm not, Your Honor.
Is it possible for a court to go into a neutral analysis in this type of situation?
I think the neutral analysis is there, and that is, did the congregation meet and did it vote?
But I mean, I'm not saying this situation, in any type of situation where they're looking at whether something occurred, is it possible, or is it just categorically not possible?
I think there is, the only inquiry that the court makes is at the beginning to see, one, was this a minister? Two, is this an employment case? Does this involve the minister's employment? Because if it doesn't, then you can go into looking at pretext and these reasons. However, if those two questions come back in favor of the church, then no, the
So
court
if it's not an
can't.
employment then case, if it's not a wrongful discharge, then maybe?
Maybe. Because the cases we're citing address employment decisions. That's the right of the church to select, control, retain, terminate its ministers so that they can ensure that they have the people in place who are following the tenets of their faith.
I think we understand your position unless you have anything else.
I have nothing else to add. Thank you.
Thank you. Mr. Smith, you have about 3 minutes left. Are you aware of any cases that have carved out, in state or federal, that have carved out an exception? Well, that they didn't give them the full facts at the congregational vote, so therefore we're going to allow this to be litigated?
No. I'll be frank with the court, no. But again, to the judge's question, there is a compelling reason to look behind the vote here, because the people who made this statement to the congregation were hiding their own criminal conduct. The deacons violated the law by not making their mandated report. The preacher violated the law by not making his mandated report. The West Virginia Code specifically states ministers and people in the church are required to make these reports. If you take their position, then ministers can flaunt the law and refuse to obey the law, which is again not a violation of substantial public policy.
Why exactly is it compelling in this case?
In this case, you have two things that went on. One, the stated reasons for her being discharged was, one, she doesn't get along with coworkers. They didn't say anything about why. Secondly, they did not allow any questions or any kind of discussion. If you look at the statement at the end, they say, we're not going to take any questions, we're not going to talk about it. You vote on what I just said. And they are hiding what they did.
That's not exactly compelling, though, is it? What's the actual reason it's a compelling interest?
It is compelling because the people who gave the statement to the congregation were hiding their oin criminal conduct. It is
Alleged criminal conduct.
No, Your Honor.
Was anything actually, was there any criminal actions taken?
No. But the people admitted they did not make the reports as they were required to. They admitted they were mandated reporters. They admitted that they didn't do it.
What is exactly the standard to give rise to a required mandate report? Is it the fact that a couple kids said, my mom spanks me?
I don't.
Yeah, because I don't, obviously, the judgment is necessary. I'm assuming there's a significant room for judgment in many cases. Now, I'm sure there are going to be some very clear cases where there's physical evidence of abuse or indication, but I think you're throwing around some pretty harsh terms that aren't substantiated in the record, only in your complaint. And I think serious charges like that would require some serious evidence. Do you have evidence that there was a conspiracy to commit a crime?
And
No.
did the prosecutor ever bring charges?
No, to answer your question. And as a matter of fact, the prosecutor was the judge in this case.
How can the prosecutor became judge?
Yes. Your Honor, to answer your question, no, we're not talking about the children saying they were spanked. They were talking about, they said that their father hit them and could hit them anywhere on their bodies. That is not corporal punishment. That is hitting your children. That is, and you are not, the mandated reporter is not in a position to conduct their own investigation. They report it and they leave it up to CPS to conduct their investigation as trained professionals. And to avoid what you have here, by the time that the trained professionals get to the kids have already been in the presence of their beaters, the people hitting them for a period of time, and then amazingly enough say, no, it didn't happen. My position would be that out of an abundance of caution, a mandated reporter would report it any time that it is like it could be abuse. That's what protects them. And in this case, the reporters did not, which is a crime.
I think we understand your position. The case will be submitted. Thank you very much.
Please rise and remain standing until the judges leave the room. This court will